Good morning. We're going to consider two Ninth Circuit nominees this morning, and I believe Senator Cotton is here to make an introduction, and we'll just lead off with you, Senator Cotton.
Thank you, Mr. Chairman. Senator Feinstein, members of the committee, I am honored today to introduce my old friend Ken Lee as a nominee to be Circuit Judge on the Court of Appeals for the Ninth Circuit. I hope I haven't hereby doomed his chances. Joining us today is Ken's wife, Melissa, his mother, Joyce. Ken and Melissa's girls, Alessandra and Sophia, couldn't make it. Sadly, neither could Ken's father, Stan, who passed away in 2010 after a battle with cancer. But I know how proud he is looking down on his son today, and for very good reason. The Lees embody the American dream. Stan and Joyce left the economic and political turmoil of South Korea in 1980, bringing with them a 4-year-old Ken and his 3 sisters. They settled in the Koreatown neighborhood of Los Angeles. Ken's father had been an engineer in Korea, but now he worked 6 days a week, 13 hours a day, fixing spray paint machines. His mother went to school at night to become an acupuncturist. Together, their honest work in their new country provided for the Lee family. As important, Ken watched his parents in those years and learned about grit, perseverance, sacrifice, and hard work. From those working class roots in an immigrant community, Ken did well enough to earn a spot at Cornell, where he was a top student in his major, and then at Harvard Law, where we first met. Ken was a third-year student when I was a first year, so he didn't need to give me the time of day, but he did. Ken gave me tips on classes, summer jobs, and clerkships. He was kind and thoughtful, generous with his time and wisdom, even when there was nothing in it for him. Ken even chose me a lot during basketball pickup games, though I have to confess that Ken is a much better lawyer than he is a basketball player. But you don't need me to tell you that Ken Lee is an outstanding lawyer. An appellate clerkship, service as a counsel to President George W. Bush, work on this committee during the confirmation of the Chief Justice, teaching law students at Pepperdine, and private practice at 2 of the country's top firms. It's all there on paper in front of you. I'm here to speak for Ken's character. This is a man who didn't just give a hand to a first-year law student. He mentored minority students and he coached youth baseball in Harlem. He leads an active pro bono practice, working hundreds of hours to protect the helpless and the powerless. Inmates abused by prison authorities, Coptic Christians fleeing persecution, homeowners facing foreclosure. The Ken Lee I knew 20 years ago is the same Ken Lee who stands before you today, a man of humility, generosity, thoughtfulness, and integrity. Now, I understand that some of you are upset about blue slips, and I know that some of Ken's views may not be your cup of tea. That's fine. Let me suggest if you disagree with him, then just vote against him. Ken's a good man. He won't hold a grudge, which is more than we can say about most of us senators. But it's wrong to manufacture spurious process fouls or to question his character. Have the courage of your convictions. Just say you disagree with them. We'd all be better off if more of us express those views openly, but acknowledge that a political or judicial disagreement doesn't necessarily imply a bad character. Quite the opposite with Ken Lee. I think you'll find today that he's not only a brilliant lawyer, but more important, he's a man of high character. I trust a majority of this committee and the Senate will support his nomination. I'm proud to call Ken Lee a friend, and pretty soon I'll be proud to call him judge.
Thank you very much, Senator Cotton. Appreciate you coming to the committee. Thank you very much. We're going to be hearing from two nominees today that the ABA unanimously says are well qualified. Daniel Collins and Mr. Lee, just introduced by Senator Cotton. Neither has had the blue slip returned. I think you understand where I'm coming from on that. I think there's been a lot of consultation here. From my point of view, it's time to move on. In this case, Mr. I guess it was Lee, supplemented writings. You turned over 515 pages of writings. We found more. You turned in 61 pages, which is not unusual. Appreciate you doing that. We held up his hearing the first time because we received his materials late from the White House. They missed it by a day. So I'm trying to let the White House know that our numbers matter, that to get the background check done, we delayed it to make sure that was done. We've had supplemental writings submitted. From my point of view, the process has been fair. May not like the outcome of how this works, but I've tried to be sensitive to the idea that the background check did have holes in it and we're required a delay to get it done. I'd want that for us. They missed the reporting date by a day. Hopefully, I know they got a lot going on at the White House, but we're going to hold to the time schedule. And the supplemental writings have been submitted, and we appreciate that. And so I feel like from a process point of view, we've been fair to the committee, and it is now time to have the hearing. With that, I'll turn it over to Senator Feinstein.
Thanks, Mr. Chairman. I'm really very concerned by the fact that there are no other members on our side here. These are circuit court nominees. They are controversial, and it seems to me that we ought to have a full presence on our side, and that's not your problem, it's my problem. But I do want to say that. I'm very disappointed that the committee is holding the hearings. As you know, both Senator Harris and I have not returned our blue slips on either Mr. Lee or Mr. Collins. So the result of this action is to effectively kill the blue slips for the circuit court, at least as long as the control is on your side. I've spoken at length on the importance of the blue slips, so I'm not going to restate everything I've said, but around here, what goes around comes around. And the blue slip, in the 25 years I've been on this committee, has been an effective way of ensuring that home state senators, regardless of party, have a say on the nominees whose decisions will directly impact their constituents. So I really regret that this hearing is being held when two blue slips from the state that this nominee will represent have not come in. And as we have publicly stated, our opposition to both is well-founded. So let me go into it. In Mr. Lee's case, he failed to provide over 75 articles to our Judicial Selection Committee, despite repeated requests to do so. While many of these writings are from his time in college, others date from his time as a practicing lawyer. In addition, the committee received 60 pages of articles that had previously been unidentified in the days before this hearing, and over 18 months after he was interviewed by my bipartisan in-state committee. Further, these articles were submitted only after my staff and the press identified individual writings that were missing. Given these repeated omissions, it's reasonable to ask whether there are additional pieces authored by Mr. Lee that still have not been turned over, and I will do that. We can ask Mr. Lee about these writings as they demonstrate very strong personal views on issues including immigration, affirmative action, and voting rights. I've also previously indicated concerns about Mr. Collins' nomination to the Ninth Circuit. As Senator Harris and I noted in a joint press release, our in-state vetting process issues with Mr. Collins' temperament and rigidity. Specifically, our vetting process had identified that Mr. Collins has, and I quote, a history of taking strong litigation positions for no reason other than attempting to overturn precedent and push legal boundaries, end quote. In reviewing Mr. Collins' record, There are additional concerns about position he's taken on women's reproductive rights, the use of military commissions to try enemy combatants, and its views on the rights of criminal defendants. And I have questions about a provision on the 2006 Patriot Act that Mr. Collins is said to have authored, which stripped federal district court judges of the power to appoint interim United States attorneys. Mr. Chairman, it's not too late to return to honoring the blue slip of home state senators of both parties, not just on district court nominations, but on nominations to the circuit as well. I hope you will do that, and I hope that after this hearing today, you will not allow these nominees to receive a committee vote or advance to the full Senate. I would hope that members on this side would attend. This is an important hearing, and I'm very concerned that our members are not present. Thank you, Mr. Chairman.
Senator Blumenthal is present. So,
Correct.
so if the nominees would come forward, please. Would you both raise your right hand? You solemnly swear the testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God. I'll introduce Mr. Collins. Mr. Lee has been introduced by Senator Cotton. Mr. Collins graduated from Harvard, undergraduate, Phi Beta Kappa, JD from Stanford, served as the editor of the Stanford Law Review. He's had 2 clerkships with Judge Dorothy Nielsen, a Carter appointee on the Ninth Circuit in California. Then he clerked for Justice Scalia on the Supreme Court. He's got extensive experience both public and private sector. He served as an assistant advisor to the Justice Department Office of Legal Counsel. After clerking for Justice Scalia, he served as an assistant United States attorney in Los Angeles for 4 years, where he prosecuted over 60 criminal cases, including 8 jury trials. In '96, he joined the law firm of Munger, Tolles, Olson in Los Angeles as an associate. 2001, he joined the Justice Department, served as Associate Deputy Attorney General, focused on legislative initiatives to combat child pornography, child abuse, and to reform federal sentencing laws. He also played a key role in the creation of the Civil Rights Division's guidelines prohibiting the use of racial profiling by federal law enforcement agencies. He also served as the Chief Privacy Officer. In 2003, he joined Munger and practiced and focused on appellate law. He's one of California's leading appellate lawyers. Since 2015, Mr. Collins has been recognized by Best Lawyers in America for his appellate practice. 2012, he was listed one of the super lawyers as a top-rated lawyer in appellate practice for the entire country. Chief Justice Roberts appointed Mr. Collins to the Advisory Committee on the Rules of Evidence in 2014 and reappointed again in 2017. He teaches appellate advocacy and federal courts as an adjunct professor at Loyola Law School in Los Angeles. He was rated unanimously well qualified by the ABA. With that, Mr. Collins,
Thank you, Chairman Graham and Ranking Member Feinstein, for holding this hearing, and I thank all the senators for your consideration of my nomination. And I'd like to thank President Trump for making that nomination, and I would hope that I would earn the trust that's been reposed in me. I'd like to also thank and introduce my family members, starting with my beautiful wife, who's behind me now for almost 20 years. She has been a source of joy, support, grace, love, and laughter in my life. I like to say that we were, as it were, match made by God himself, because we met in the sanctuary of our parish church, about 10 feet from where we were later married. You see, my wife was the cantor at the time in the parish, and I was one of the lectors, and the lector sits next to the cantor during Mass, and I will confess to you that I did not always give the Mass my full and undivided attention. I'd also like to introduce my 3 children who are also here. My oldest is John Paul. He is a senior in high school. He's now going through the college application and decision process. He is a very bright student. He likes to think about deep political and philosophical issues. He's also a very compassionate man, except if you face him on the tennis court, where his brutal lefty serve will crush you like a bug. He's one of the star players on his high school tennis team. Then there's my daughter, Kira, who is multi-talented. She's a freshman in high school. She is also a great tennis player. She was a captain of her volleyball team. She's now starting lacrosse. She sings almost as beautifully as her mother. She's also a great baker. As I said, she's multi-talented. And then my youngest son is Seamus, and he is just applying to high schools. He's also a very bright young man. His passion is baseball, both as a player where he excels and as a fan of the Los Angeles Dodgers, where he has had to experience the highs and then the lows in the last few years of making it to the World Series and not quite closing the deal. And then I'd also like to introduce my siblings who are here. My brother Tim, my sisters Chris and Ginny are also here, my sister-in-law Marie, and my nephew Harry, and then my good friend of many years, Mark Savage, who flew in from California for this hearing. I'm sorry that my parents cannot be here for this moment. They both passed away many years ago, but I owe everything I have to them, and in particular to my mother, who is a very strong person and taught me the importance of education and of good values. And I'd be pleased to answer any questions you may have.
Great. First of all, I want to thank this committee, in particular Chairman Graham and Ranking Member Feinstein for holding this hearing. I also want to thank Senator Cotton for that nice introduction, and I also want to thank the President for nominating me. Before introducing my family members, I just want to make a brief statement about concerns raised by some senators about how some of my documents were produced. As this committee knows, I provided over 500 pages of my writings since I was a teenager. Most of those writings were during my college time. I made every good faith effort to collect everything that I had. I went through my personal files, my electronic files, internet searches, online databases, my firm's library of articles. I even went to my mom's old house, went through the garage, through boxes of old baseball cards, scrapbooks, and I did find a few additional articles I had written as a teenager, and I provided them to this committee. It later came to my attention that there were additional articles which were found in non-public sources. For example, I think some were found on a private server held by someone, and I provided them to the committee immediately after we found them. I apologize for this. I know it's causing inconvenience, and it's frustrating for me as well, and I hope this committee understands that. Now I want to briefly introduce my family members here. First of all, and most importantly, behind me is my wife, Melissa. Melissa has a heart of gold. She's dedicated her life to helping others and to public service. She started off her career as a social worker in inner city Baltimore, helping underprivileged youth. And then she became a career civil servant and worked under the administrations of both President George W. Bush and President Barack Obama. She is the most tolerant and understanding person I know. She tolerates my many flaws and the mistakes I make. And importantly, she also tolerates the fact that I dress up our 2 daughters as Star Wars characters every Halloween. And that brings us to our 2 daughters, Alessandra and Sophia. They are a spirited bunch, and by spirited, I mean if they were here, they would be singing Wheels on the Bus out loud. That's why they're not here. They're back at home with my mother-in-law. I also want to introduce my mom over here. My mom is my hero. When our family immigrated to the United States, my parents were middle-aged, had 4 kids to support, and didn't speak a word of English. So we settled down in the Koreatown area of Los Angeles, and my parents found whatever job they could. And growing up, I remember my mom taking care of my 3 older sisters and me in the morning. She'd go to work, she'd come back, take care of us, and then she'd go to school at night to learn a new skill as a middle-aged woman. So proud of my mom and feel so blessed. I also want to mention my 3 older sisters. They're back home in California. I looked up to them growing up, and I learned so much from them. I also want to thank so many of my friends who are here today in this room. And finally, I want to mention someone who's no longer here with us, but without whom I would not be here today, and that's my dad. My dad was the hardest working man I knew. He worked 60, 70 hours a week, 6 days a week, and literally never took a day of vacation. And one of my dad's favorite sayings was, "This is why America is the greatest country in the world." He would say that whenever he liked something. So for example, whenever we want to celebrate something, he would take our entire family to Sizzler's all-you-can-eat buffet for $8.99. And as he put in, a couple extra tater tots and chicken wings on his plate, he would turn to me and say, "See, this is why America is the greatest country in the world." I never had the heart to tell him that there were other culinary options than $8.99 all-you-can-eat buffet, but he loved it. And another thing he loved was the American legal system. Although he wasn't a lawyer, he loved hearing stories of a single man or single woman fighting the government or a large company or the powerful and winning. Because he said back in our native homeland, stuff like that never happened. He mentioned that the laws would always bend to favor the powerful, the privileged, and the politically connected. But he said here in America, things are fair and equal. Perhaps my dad had a slightly idealized view of our legal system, but that's why I wanted to become a lawyer. And in my 20 years as a lawyer, I hope I tried to honor the faith that my dad had in the legal system. I've served as a lawyer in all 3 branches of government. I've tried my best as a lawyer in private practice, and I'm particularly proud of hundreds of hours I've devoted to pro bono cases, helping the poor who cannot afford legal representation and members of marginalized groups who may not have access to legal justice. And I hope I can make my dad proud today. Thank you.
Thank you both very, very much, and your stories tell a lot about you and the country. Mr. Collins, you've had 60 cases that you prosecuted at DOJ. Is that correct? I think 8 jury trials?
Approximately. The 8 jury trials includes one that was a retrial of a hung jury. So
Okay. 38 arguments before the Ninth Circuit.
I think that's right. It may be 39, but it's about that, yes.
All right, well, it's 38 today.
May have been updated.
Yeah, okay. And 14 appeals you participated in to the Supreme Court, is that correct?
I've never argued in the Supreme Court, but I've filed a number of briefs in the Supreme Court, yes.
About 14 times, is that right?
That sounds about right.
Okay. I'm just checking my staff to make sure they know what they're doing. What have you learned from all this?
I learned that the law is profoundly important to our society, and that the fair administration of justice is critical to ensuring our rights, ensuring the functioning of the
Well, as a
system.
trial lawyer, what did you learn versus being an advocate before the appellate court?
Well, it was being a trial lawyer, and in particular being an AUSA, and the cases I focused on were mostly violent crime cases. You really had a sense of kind of the immediacy of your impact. I remember one case in particular that I co-tried with one of my colleagues, and the victim's family came every day to the trial. It was a horrific case involving a kidnapping and a rape, and the victim suffered terribly during the trial and the testimony. And after the conviction, I mean, the whole family came up, the grandmother comes up, gives you a hug because you've delivered justice to them in a very concrete way. So that was a very moving experience for me.
So
as a
that leads
trial
me
lawyer.
to my next question. This committee engaged in a bipartisan effort to change our sentencing laws in a way that I'm proud of and the president signed. You know, you've been a former prosecutor. I understand sort of where you're coming from. How do you feel about the First Step Act?
I think that the First Step Act, it appeared to me to be a balanced approach to reform some of the some of the sentencing provisions which seemed unduly harsh and needed some.
For nonviolent
modification.
offenders. Right. Mr. Lee, you wrote a lot as a young person.
I did, Senator.
Why?
Senator, I think when I entered college as a 17-year-old, I started to become interested in current events, and I started reading newspaper columns, watching television, the McLaughlin Group, and radio. And I think when you're
You
young,
watched the McLaughlin Group as a kid?
I did, and yeah.
About to lose me, so keep going.
And so I started to become interested in them. I started writing about these issues. And when you're 18 or 19, you think you know everything, even though you really don't. And not only that, you think.
When did you realize you didn't know everything?
I think by the time I was probably in my mid to late 20s, it's a slow process, but you realize you don't have the life experiences. You don't know.
Did having kids help you understand you didn't know everything?
Absolutely, Senator. Having kids, being married has absolutely helped me. Become more empathetic, more understanding.
Let's talk about diversity and affirmative action. You've written about it. You have opinions on it. You have a compelling life story. Can you tell us what shapes your views about the concept of diversity and affirmative action in our law and our society?
Sure, absolutely, Senator. When I wrote those pieces in affirmative action, I was in the 1990s, and it was a big issue in the Asian American community. And we're not a monolithic community, but a lot of us were concerned that some schools were using affirmative action to discriminate against Asian Americans. And obviously at the time I was applying to school, so that was something that was of interest to me at the time. And in particular, I think there was a concern because there's a history of discrimination against Asian Americans, from the Chinese Exclusion Act to Korematsu to the Vincent Chin case. And there was also a feeling, I think, in the Asian American community at the grassroots level that our voice wasn't being heard. So there was a lot of push of let's write about it, let's hold rallies, let's write to our elected officials. And that was part of it, Senator, that I wrote about that at that time, Senator. But obviously, Senator, and at that time when I wrote it, I think there was a question of whether the Bakke decision from 1978 was still valid. I think the Supreme Court has held in the Grutter and Gratz case, and then later in the Fisher case, that affirmative action in universities is permissible, and that racial diversity is compelling interest.
Senator Feinstein.
Mr. Chairman, I trust that each member has 5 minutes for each.
Yes, and we'll just be very liberal, we'll 5 minutes for each, and if you need another round,
Okay,
we'll
thank
just
you. Let me
make sure we have a
begin
thorough
with
hearing.
Mr. Lee. I'd like to know about your submission of articles, and particularly the failure to disclose some controversial ones. Maybe you could discuss the steps you took to identify the universe of your writings before making submissions to this committee, and then explain the failure to turn over more than 40 articles that you had written during college.
Good. Thank you, Senator, and I understand your concerns about that. Senator, when I got the Senate Judiciary questionnaire, it asked for all articles I had written, and I started the process of looking through my personal files, and I had a scrapbook of articles I had written, so I collected those. I searched my electronic files because I had my computer with PDF files of things I had written. I collected those. My firm also maintains a library of articles I had written as a lawyer, so I went through those and collected those. I also went to the internet and did many, many internet searches to find articles. I also went to databases, LexisNexis, to find articles. I also went to my mom's house, where I still have a lot of my stuff there in the garage. I went through many, many boxes trying to find articles. And in total, I think I had provided over 500 pages of articles, most of which I had written during my college time. And I believe that was all of the articles I had written. There was a lot of them. Later came to my attention that there were additional articles. And again, I think they were found through non-public sources. These articles were written 20 to 25 years ago. It was before the internet era, so these articles were not on the internet that you can search and find. I mean, I think some of these articles we found on a private internet server that someone had. It was, I think, like the URL is like 192.238.021. And someone apparently had scanned these 20-year-old articles and put them in his private server, but when he scanned it, it wasn't searchable, text searchable, therefore it didn't appear on the internet. And once I discovered those, I immediately provided them to the committee. And with respect to these articles, again, the topics were similar to what I had written before. So, in my mind, I believed I had provided everything. But again, I apologize to this committee for that. Obviously, it's frustrating for this committee and a major inconvenience.
Well, let me discuss one article that I have, and I don't know whether it's really relevant or not, but it's the Council Review, February 10th, 1994, and it's about AIDS. And there's a indented quote, 9 out of 10 people with AIDS are gay or drug users. And you make certain arguments. Is this article true of your perspective today? And if you wrote an article like this today, what would you say?
Senator, I absolutely would not write that today. I truly regret writing that. When I wrote that article, I was 18 years old, and it was a completely misguided attempt I was trying to defend President Reagan's AIDS policy, and I was trying to say it was consistent with risk levels. But frankly, as an 18-year-old, I didn't know anything. I didn't know science. I didn't know epidemiology. I was parroting something, I had read somewhere. And, frankly, looking at that now, 26 years later, I'm just embarrassed by it.
Well, I don't want to waste time because I appreciate your answer. And what has changed for you now? The important thing is, how do you view these issues now?
Thank you, Senator. I think over the years, you gain more empathy. When you go through life, the good and the bad, the difficult things, and just different people you meet as well. I mean, I personally know someone who is living with that disease, and just thinking about, and it's a person I respect, thinking about him reading what I wrote as an 18-year-old is mortifying, frankly. Again, just over 25 years, you mature, you become more empathetic, you learn things. I like to think I've matured as a person over the past 2.5 decades, Senator.
Well, thank you for that answer, and I appreciate it very much. Mr. Collins, I understand you drafted a provision of the 2005 Patriot Act reauthorization that removed the ability of federal district court judges to name interim United States attorney appointments. And in 2006, Attorney General Alberto Gonzales fired 9 U.S. attorneys for political reasons. The Bush administration then used your provision to fill those open vacancies indefinitely and bypass Senate confirmation. You stated that you did not anticipate your provision creating an open, this is a quote, an open-ended feature. Why did you decide to strip federal district court judges of their authority to fill U.S. attorney vacancies?
I actually did not draft the provision that ultimately was enacted. What happened was in 2003, when I was still in the department, I believe it was July of 2003, I was asked whether there were additional proposals that we wanted to include in a proposed DOJ reauthorization bill. I suggested, largely driven by the significant blowback the administration had gotten from the bench on the PROTECT Act, that we consider removing the courts from appointing interim U.S. attorneys because of the policy conflict between the two branches at that point in time. When I returned to my firm about a year later in 2004, I got an email from Will Michella asking me essentially, do you remember that idea you had? What was the section? And I sent him back the section, and I suggested different alternatives in language. The language that was ultimately used in 2005 and enacted in 2006 is not any of the options that I had provided in that email. They came up with their own language to implement the concept.
The part that concerns me is bypassing Senate oversight, Senate confirmation.
Well, one of the options I had listed, although I recommended against it because of its complications, was the Vacancies Act, which has constraints on it. There were a variety of different ways it could have been done. I did not envision what was going to happen with that and what did happen. As I said, I originally
You had
proposed-
no intent to create any situation whereby a president could decide to bypass a confirmation process.
I did not foresee that it could be used. When you read the text of it, you realize that, yes, that could be done. You could do it indefinitely. And that was not something I had really thought of. I was more focused on the thought that when there was, policy conflict between some of the judges in some districts and the administration on sentencing issues, it was probably not a good idea to have the bench appointing the United States Attorney for that district.
So you do not feel that way today?
No, it was quickly repealed, and it's been put back in place, and I accept that that's how the law stands today.
Okay. You also filed an amicus brief in the 2006 Hamdan case, a very famous case, Hamdan v. Rumsfeld, in which you argued that President Bush properly exercised his authority as commander-in-chief when he established military commissions to try Guantanamo detainees without explicit authorization from Congress. The Supreme Court disagreed with you and held that the commissions violated both the Uniform Code of Military Justice and the Geneva Conventions. In July 2006, testimony before this committee, you suggested that Congress should, quote, move promptly to overrule, end quote, the Hamdan decision by statute. So here's the question. What's the basis for your conclusion that military commissions are better suited than Article III courts to try terrorism suspects?
Well, there was, I think, a broad consensus among a number of people at the time that military commissions should be retained as an option because they provided somewhat greater flexibility for particularly difficult cases. The Congress ultimately did adopt a Military Commissions Act in 2006 that then was the subject of a further Supreme Court case.
Do you share that? Do you have that view today?
At this point, as a nominee to an Article III court, I'm not going to get to have policy views on those kind of public issues which are for the political branches to resolve.
Okay, let me ask you another one. Do you believe that trial by military commission is appropriate for U.S. citizens accused of terrorism in the United States?
I don't know that I ever specifically opined on that question.
I don't know whether you did or not. I'm asking you the question.
I don't think it would be appropriate for me to answer that kind of hypothetical. That's something that could come before the courts.
Well, I'm not sure that's a valid reason that a trial by a military commission for a U.S. citizen accused of terrorism could be held by a military commission as opposed to a court. So you're saying you don't have an opinion on that subject?
No, I'm saying that, that kind of a claim that a military commission would be inappropriate is something that someone who was contesting that procedure would then file in a court, and I don't think it would be appropriate for me as a nominee to a court to opine on that open question.
Let me move on. In a case about a city ordinance requiring pregnancy clinics to disclose if they don't provide abortion services, you argued that this ordinance violated the First Amendment and, I quote, serves literally no purpose other than to burden clinics' protected speech. Please explain your reasoning on how putting out a sign notifying a woman of services provided and not provided is a burden on a clinic's free speech.
The Fourth Circuit, in that case, unanimously invalidated the ordinance as a violation of the First Amendment. The court held that it really was not an attempt to regulate commercial speech. It didn't regulate professional speech. And given that the trigger for application of the ordinance was whether or not you communicated information about particular services, made the trigger for it implicate the First Amendment, and it struck it down.
In 1995, you wrote a book review in which you appeared to support the position that Miranda v. Arizona, a longstanding Supreme Court precedent that protects the rights of criminal defendants, should be overturned. Specifically, you wrote that Miranda should be, quote, jettisoned in favor of constitutional text, end quote. Explain your understanding of what it means to follow precedent and what jettisoning it would mean.
Well, the Supreme Court in Dickerson rejected those academic arguments in that law review, which I also did an amicus brief in the Dickerson case, and I would be bound by that decision and would faithfully apply it. I would also point out in my amicus brief in that case, I pointed out that the validity of the Miranda warnings was not at issue, and that we were not questioning that in that brief. It was the question of the remedy and whether or not the statute that Congress had passed on that subject was unconstitutional.
Thank you. I think my time is up.
Thank you. For your information, U.S. citizens cannot be tried by military commissions. That's in the statute. So, Mr. Hawley, Senator Hawley.
Thank you, Mr. Chairman. Mr. Collins, let me start with you. Can you describe to me your judicial philosophy? Tell me what you think the role of a judge should be.
I think the role of a judge is to apply the law fairly and impartially to the facts of the case. I think with statutes, you would start with the text of the statute, apply the appropriate canons. You'd have to consult the relevant precedent, be bound by what the Supreme Court has said. I'm here as a nominee to what Article 3 terms is an inferior court to the one Supreme Court, and I would have to follow what they'd say.
You mentioned interpreting text just now. That's, of course, what we do every day as lawyers and what you'll do every day on the bench. Tell me about how you would go about interpreting a text, whether it's a statutory text or a constitutional text. What are the tools you would use? How would you approach it? Give me some visibility into your thinking there.
Well, if there's a relevant precedent on point, I'd have to start with that. If there's no precedent, then I think you look at the original public meaning. What would the words have been understood to the legal community to whom they were proposed for adoption, and try and get a sense of what the rule was that was established by that, and then take that rule and then apply it in the contemporary circumstances of the situation and the case at hand.
Mm-hmm. Say a little bit more about original public meaning. What do you mean by that?
By original public meaning, it doesn't mean the subjective intent of the persons, what they had in their head. It means when you put the words down on paper, what do educated lawyers who understand the legal system and the doctrines, how would they read those words? What would they understand the rule being established to be, and then carry that rule forward?
Let's imagine a case where there's an absence of precedent, so it's a case of first impression, and it's a statutory interpretation case or a constitutional interpretation case, doesn't particularly matter. You've got various options. You've got the text, you've got structure, you've got history, you've got purpose, you've got legislative history, you have contemporary values, you've got canons, which you mentioned a moment ago. How do you prioritize those and deploy those different tools or considerations?
Well, as I said, if there's a precedent on point that construes it, then I'm going to have to follow that. If not, then I think you start with the plain meaning of the words. The Supreme Court has has put considerable weight on that. If there's an ambiguity, then you may need to resort to the canons in order to be able to resolve that, and in many cases it often does.
Purpose, how does that?
I think it's important to understand the context. I remember a case that was decided by the court the year that I clerked. It was a tax case where the statute was it was enacted in response to two Supreme Court cases. And so in trying to figure out what this vaguely worded statute meant, and Justice Scalia wrote the opinion, he did take into account that it was an effort to overrule those cases. And so a reading of the words that didn't change the result in those cases was disfavored, and he adopted the one that would change that. So sometimes you have to look at the larger context of the problem and understand that. I think that's part of what it means to understand the words in the context of the public meaning that well-educated lawyers who understand the situation and the rules would attach to it.
Mr. Lee, let me turn to you. Same question, judicial philosophy. Tell me how you understand the role of a judge.
Thank you, Senator. I think the role of the judge is to interpret the law, not to impose his or her own personal views. And I think in interpreting the law, the first place to look at is the text of the statute, obviously barring any precedent that controls the facts of the case.
And what about when it comes to statutory interpretation or constitutional interpretation? How would you proceed there?
Senator, again, I think you always start with the text, and if the text is unambiguous, I think your inquiry ends there. If the text isn't clear, I think you could look at the structure of the statute or the Constitution. Obviously, for Constitution, also you look at the history as well. And I think usually by looking at the text, structure, and history, they'll often provide the answer.
Let me ask you about this. How should Congress's own constitutional judgments be weighed by a court? If Congress has expressed a judgment on the meaning of a constitutional text, let's say, whether it's the 14th Amendment, Section 5, or through some other means, how do you think a court ought to weigh that?
Senator, obviously, I think the courts have to give some deference to the legislature. I think it's very important, and there are canons of, for example, statutory construction that statutes have to be construed in a way to avoid constitutional problems. But obviously, the judicial branch is an independent branch, and I think judges take an oath to uphold the Constitution. So the courts are an independent branch, and they have to make their own independent judgment as well.
What does substantive due process mean to you?
Senator, substantive due process obviously has a long history. There was economic rights embedded in substantive due process in the Lochner era. The word substantive due process don't appear in the Constitution, but the Supreme Court has held that there is a liberty interest in the due process clause. And obviously, as an inferior court judge nominee, if I were confirmed, I'll be bound to follow the Supreme Court's precedent in that area.
Because it is precedent, right?
Yes, Senator.
Mr. Collins, same question to you. Substantive due process, what does that concept mean to you? How do you understand that doctrine?
Well, it's been a subject of some controversy. I always remember in law school, Dean Ely at Stanford referred to it as something similar to green pastel redness. But it is firmly established in the doctrines of the Supreme Court. It's both the basis on which the court has incorporated the Bill of Rights as against the states for most of the Bill of Rights, and also has acknowledged certain unenumerated rights. I would be bound by those precedents. I would faithfully apply them.
Do you understand a distinction in the doctrine between the incorporation cases and the unenumerated fundamental rights cases?
Yes, in the sense that, I know, for example, Justice Scalia was willing to, in the McDonald case, he agreed that with the line of incorporation cases based on substantive due process as opposed to resting it on the privileges or immunities clause because the precedent was so settled. But it's a distinct line of cases that looks to unenumerated rights in terms of substantive due process.
Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Welcome to you both, and congratulations on your nominations and your families very impressive families being with you today. Mr. Lee, you did write a lot, and some of those writings are deeply troubling. Maybe they're troubling to you as well, and I want to give you a chance to explain some of them to the committee. In the time that you were at Cornell, there was a scandal involving sexual harassment. And you may recall that you characterized the professor's actions giving rise to that scandal as quote unquote kindly acts. You talked about the motives of women alleging the harassment as being quote propagated end quote by a course that they took, giving them the quote pernicious view that all women are victims of the inexorable sexism inherent in our patriarchal society, end quote. You wrote in a separate article, quote, charges of sexism often amount to nothing but irrelevant pouting. So I'm wondering, particularly in light of what we've seen in the Me Too movement, the conviction of Larry Nassar, the charges against Harvey Weinstein, convictions of Bill Cosby and others, sexism, in your view, amount to irrelevant pouting?
Senator, I understand your concerns, and I can tell you issues of sexism is very concerning to me, important to me, especially as a father of 2 young daughters and as someone who has 3 older sisters who I admire so much.
Why did you write that?
Yep. Senator, when I wrote that article, I was 19 years old, and I was trying to defend a professor that I had known and admired and respected at the time. Frankly, at the time, I didn't have the life experiences of how the workplace works. You know, my only job before then was as a newspaper boy a few years before, delivering papers in our local neighborhood. So I didn't understand the dynamics of how things work in the workplace. You know, and frankly, I also was very naive. You know, the thought was, you know, I don't engage that kind of behavior. My friends don't engage in that kind of behavior. And at that time, we didn't hear too much about these type of stories. I think now we know why we didn't hear those stories. So, you know, I think I had a major blind spot on that. Over the course of the past 25 years, as I entered the workforce, I've understood how these workplace dynamics work, how, you know, women can be mistreated by superiors, and, you know.
Let me ask you, do you think women should be enabled, and do you think they have the right under our law now to decide when to become pregnant and when not?
Absolutely, Senator.
That is a moral right?
Yes, Senator.
And it's a legal right?
Yes, Senator.
Do you think Roe v. Wade was correctly decided then?
Senator, Roe v. Wade is an incredibly important decision, and it's a landmark decision. It's a decision that is relied upon by millions of people, and I will faithfully apply that precedent.
But you do believe that it is a moral right for women to decide when to become pregnant. That's what you just said. Do you think there's also a moral right against segregation, whether it's in education or healthcare, segregation based on race or religion or any other such category?
Senator, segregation is immoral.
And wherever it occurs?
It is.
And it's also illegal. And do you believe Brown versus Board of Education was correctly decided?
Again, Senator, Brown v. Board is one of the landmark decisions. It has a personal meaning to me, obviously, as a minority. That's the reason why I was able to attend schools that aren't segregated.
If you'd been on the Supreme Court, would you have voted in favor of that outcome?
Again, Senator, I think it's an incredibly important decision. It's a landmark decision. Obviously, I would think it's one of the most important decisions the court has issued in reversing Plessy-Ferguson and the odious principle of separate but equal.
You know, I'm not surprised by your declining to answer my question, whether it was correctly decided, what do you think your father would have said?
You know, my dad believed in equality.
Don't you think he would have said, yeah, it was correctly decided, that's what makes America great?
I never talked constitutional issues with my dad, but my dad believed in equality and then that everyone should be treated equally, and that's where I learned that important lesson.
Mr. Collins, do you think Brown versus Board was correctly decided?
Brown versus Board of Education, one of the most important landmark decisions of the Supreme Court that consigned the separate but equal doctrine to the ash heap of jurisprudence. But as a nominee to, as I said, what would be an inferior court to the one Supreme Court, I'm not going to purport to undertake to grade the court's homework. They would grade mine if I'm fortunate enough to be confirmed.
You know, I'm going to suggest to the administration that they just give you a sort of maybe a sign that you can hold up saying, answer 1, answer 2, because I'm receiving the same answer from every judicial nominee to that question, whether you believe that these two landmark decisions, they are landmark decisions, were correctly decided. And I'm just at a loss to understand why no nominee is agreeing to answer the question, and how every nominee is using almost exactly the same language to avoid answering it. And I think it is unfortunate, because I think we ought to have free and open answers, particularly on that kind of moral as well as legal question. Let me ask you, Mr. Lee, among your writings, you said in 1994, quote, while most people can agree that gays should be accorded respect and equal rights, the creation of another ism, like racism, is yet another way to portray people as victims in need of preferential treatment, end quote. You went on to call the oppression of LGBTQ people a, quote, quasi-Marxist paradigm of the oppressed and the oppressor. Maybe you can explain that to us.
Thank you, Senator. A lot of my college-era writings were basically my gut reaction based on my experiences as a adolescent immigrant growing up in LA. And part of the things, my dad always taught me was, America's incredibly generous country. It's free, and you can do whatever you want. And that was kind of my framework. And part of it when I came into college was some of the professors seemed to dwell only on the negative parts.
Well, let me just ask you, do you think that discrimination or oppression against LGBTQ people is merely a Marxist paradigm?
Absolutely not, Senator. And if you look at my 20-year track record, I've done pro bono cases on behalf of LGBT individuals. I've been very active in recruiting LGBT individuals to our firm. In fact, one of the things I'm proud of is, when we helped open our LA office, we had a very diverse group of people, but one thing we noticed was we didn't have any LGBT attorneys. So one of the things I did was I worked with people in our other offices, LGBT lawyers, and I had them come to LA, and we reached out to outlaw LGBT groups at UCLA and USC, and we held a forum to recruit more.
Why would you write that? Because of ignorance?
Senator, again, I think when I wrote that, it was criticism of some of the professors I had, where they seemed to dwell so much on the bad things America did, and there are plenty. We know that from our history books. And never talked about the good things that America has done as well. So that was kind of my gut reaction.
So you would disavow that?
Yes. Senator, I think when I was young, my views weren't nuanced. When you're young, your views aren't nuanced. You don't understand the complexity of the world. A lot of times you just base it on your narrow personal experience. And as you get older, you realize the world is much more, it's bigger, it's richer, it's more complex than based on your narrow experiences you had as a kid. And that's one of the things I've learned as I've gotten older.
Mr. Collins, let me just conclude by asking you about the brief that you wrote in Lorillard Tobacco Company versus Riley. You argued that restrictions on tobacco ads and sales within 1,000 feet of schools and playgrounds violated tobacco companies' First Amendment rights. Do you think corporations have rights under the Constitution?
Well, actually, my client in that case, it was invalidated on preemption grounds based on the Federal Cigarette Labeling and Advertising Act. The court held it was preempted, and then it also held with respect to the other parties, the cigar.
But let me ask you, and there are some interesting issues on preemption, but I only have a few moments. Do you think corporations have constitutional rights just like ordinary American citizens?
Well, the court held that the petitioners in that case did have a First Amendment right to communicate in commercial speech the availability of the product.
Do you think, though, that corporations have rights that are comparable to individual citizens? Are they the same under the First Amendment?
As I said, the court held that the petitioners who were corporations did have a First Amendment right to make that communication.
What about your beliefs, though?
I would follow the precedent of the Supreme Court on that issue. And
So you don't
that's
have any
settled.
beliefs on that issue?
Well, again, I don't think it's appropriate for me to sort of grade their homework. I would follow what they've established.
You don't
as
think it's
law.
appropriate to tell us anything about your personal belief?
I've told you what I did answer questions about my general approach to how I would approach jurisprudence, but to answer specific questions where the court has held this is what the law is. A corporation does have the right under the First Amendment to commercial speech to say whether I think that's wrong. I don't think that's appropriate for me to do.
Thank you, Mr. Chairman.
I'm Senator Kennedy's next, but I'm going to give you my 2 cents worth about sort of how all this works. I had 5 minutes I didn't use. Citizens United, are you both familiar with the case?
Yes, Senator.
If somebody tried to change the Supreme Court ruling, if there was a case in controversy that worked its way up through the court system, would you expect the Supreme Court to hear the other side as to why you should reconsider Citizens United?
If the court,
You would be bound by it, right?
I would be bound by it.
You would be bound by it, right?
Yes.
So if somebody in California wanted to challenge Citizens United, you feel like you'd be bound by it and if it was squarely on point, both of you?
Absolutely.
Yes, Senator.
Same for Roe v. Wade?
Yes, Senator.
Absolutely.
Now, is it okay to challenge Citizens United to the Supreme Court?
For a certain.
If the Supreme Court wanted to take a case, they could do that, couldn't they?
Yes, but, the court has said in the Rodriguez de Quijas case that where a controlling precedent is on point, even if a lower court judge thinks that other cases of the Supreme Court have undermined its premises, that the obligation of lower court judges is to follow the case on point and to apply it, leaving it to the court the prerogative to overrule its own decisions.
My point is pretty simple. Dred Scott was overruled.
Yeah.
Brown versus Board of Education. There's a legal process where the court can reconsider precedent. Do you agree with that?
Yes.
Yes.
Does that apply to every case ever decided by the Supreme Court?
No, the court generally indicates when it's willing to reconsider.
That's what
a
I'm
decision.
saying. They decide.
Exactly. They have, for
And
example.
if they want to revisit Brown versus Board of Education, they can do so. If you can ever find a case in controversy that would come before them. I can't imagine a jurisdiction in the country doing that we want to go back to the good old days of segregation. But what we're talking about is not what you believe about abortion, what you believe about guns, what you believe about life in general, but you're going to be judges. And I want the whole country to know that there is a system in place that if you have a problem with the way the law is written statutorily, or if you have a problem with the constitutional precedent, if you think Citizens United was wrong, there may be a day where the court will revisit that. I hope they do. There are people believing that Roe v. Wade needs to be revisited, that it was wrong. They're advocates. They have a right to make the case. Judges will decide at the Supreme Court level whether or not to revisit Citizens United, Roe v. Wade, or anything else. So an appellate judge, from my point of view, and I'm clearly not the smartest person in this room, you're going to be hearing cases and controversies before you, And when there's a precedent on point, whether you like it or not, you're going to apply it, right?
Correct.
Yes.
Same for you?
Yes, Senator.
Now, when it comes to a statute about when a woman can decide to become pregnant, you think she has that right, not the employer? Is that what you're saying, Mr. Lee?
Yes.
A lot of people believe that when it comes to terminating life of the child, that's a different situation. Do you understand where they're coming from?
Yes, Senator.
Thank you. Senator Kennedy.
I think, Mr. Chairman, Senator Ernst was next.
She came back, so, yeah.
Thank you, Mr. Chair, and thank you, Senator. Mr. Lee, you've been nominated to serve on the Ninth Circuit Court of Appeals, and congratulations on that. While vetting your nomination, I've had a chance to review your work, both as a private attorney and your service while working within the government. And Mr. Lee, I believe there is no doubt that you have the experience to serve on the Ninth Circuit. And from your work in this very committee to the Bush White House, you've demonstrated a clear commitment to public service. You've also built an extensive career in private civil litigation where you have served as lead counsel in a number of class actions alleging deceptive marketing. You really are no stranger to the courtroom. And that being said, though, there is more that goes on into being an appellate judge in the United States than mere qualifications and job history. A qualified judge, in my opinion, has to be able to set aside preconceived notions or beliefs while also holding a commitment to values that we as a country do hold so dear. Some might call this temperament, but you could also call it character. And Mr. Lee, while in college you wrote about a case of sexual harassment. I know this has already been brought up, but I'd like to hear a little bit more about it. And this was on the campus of Cornell University involving a Professor Moss. And I've had a chance to review some of your writings and would like to ask you just a few questions about it. And please feel free to delve in a little bit deeper here if you would like. In your writings, you expressed a belief regarding the credibility of survivors in that case. And is that a belief that you still hold?
I do not, Senator.
And we had a very good discussion about that in my office, and I appreciate that. If a similar situation involving sexual harassment played out today in your law firm, how would your thinking be different? Can you walk me through that?
Absolutely, Senator. I think you have to take any allegations very, very seriously, and I think that is something we didn't do in the past. And part of it we didn't hear about it. And again, I think we now know why we didn't hear much about it. And I think, unfortunately, a lot of people were skeptical of it. I think it's very important to encourage people to come forward if they're being mistreated or harassed and listen to them and take the allegations very seriously and investigate them.
Very good. Can you then describe how your thinking on the topic of sexual harassment has evolved from the time that you were in college to where you stand today?
Great. Thank you, Senator, for that question. When I wrote that article, I was 19 years old. I had never been in the workplace, so I really didn't even know how the workplace works, the dynamics, the need for people to work and continue working even if they face mistreatment. Again, I was incredibly naive about that. And over the past 25 years, being in the workplace, you see how the power dynamic works and how people, stay at jobs because they need that job. And I think the most revealing thing that we've learned in recent years is just how pervasive it is in the Me Too movement. And not only that, I think we learned that even good people, the people we admire, and the professor in question was someone who I admired and trusted, and I wanted to defend him. But what we learned is even people we trust and admire can commit these awful things. And I learned that from my wife. My wife, I think I mentioned to you, my wife and I share everything. We always call each other, FaceTime, texting. She may be texting me now that I'm probably slouching a little too much. But it was only recently that she told me that she had faced mistreatment and she has dedicated her life to public service and working at nonprofits. And I mean, these are people you think who dedicate their lives to helping others, and you would think they would treat the other employees well, but that's not the case. And I think that's one of these eye-opening things that we've learned over the past few years and over the past 25 years for me personally, of being in the workforce, it's opened my eyes, and I don't have those naive beliefs I had as a teenager.
And thank you for that, because I think it is important that we understand how our life does change through those years, and how we can start as a young, enthusiastic, maybe in your words, naive youngster, young teenager, but then through the course of your work experiences, your time involved with other types of activities, it has opened your eyes. We know that survivors do need to come forward and they need to be heard, but those life experiences change the way we view different circumstances. I know that Senator Cotton also mentioned that you have children as well, and we want to make sure that our children are able to experience life in the fullest, and have the need to be heard if something should happen. As parents, we want the best for our children, and I know you had expressed that in our one-on-one meeting as well. So I appreciate you coming forward and explaining to us the dynamics of where you were then and where you are today, and the time that I was able to spend with you in my office. It was very powerful for me to see that you were so humble and so generous with others that have gone through sexual assaults. And so thank you for that. I do appreciate you explaining that and being very heartfelt about how you are today and how you arrived at your thinking. So I appreciate the time with you. I know my time has expired, but I appreciate you fully explaining it. So thank you, Mr. Chair.
Senator Harris.
Thank you. Mr. Lee, I've heard you acknowledge that your college writings were immature and not reflective of how you think today. But you also have more recent writings. In 2007, you co-wrote an article defending laws that prohibit people from voting if they've been convicted of a crime. As a practicing attorney, you also submitted an amicus brief defending the constitutionality of one such law in New York. According to the Sentencing Project in 2010, 1 out of every 13 black voters in the United States has lost the right to vote under laws that disenfranchise individuals convicted of a crime. By contrast, only 1 out of 56 non-black voters have been disenfranchised. Based on the evidence, do you believe that these laws have a desperate impact on African Americans?
Senator, from statistics I've seen, they do suggest there is a disparate impact.
And do you believe that that desperate impact is relevant in deciding whether a law that disenfranchises an individual convicted of a crime should be upheld?
Senator, I think that's an issue. I think courts are deciding on that.
What's your perspective?
Senator, again, I'll follow the precedent, whatever it may be. As a judicial nominee, I think it's inappropriate to opine on issues that may come up before me if I'm confirmed. But
do you believe that the court should consider desperate impact on specific populations and what might result as a consequence of that court's ruling?
Senator, I think in some contexts, courts have accepted disparate impact analysis.
Do you agree with that?
Again, Senator, I'll faithfully follow all precedent.
Is there precedent dictating whether or not the court should consider desperate impact when issuing a ruling?
Senator, I will follow all precedent.
Is there precedent in this regard?
Senator, I can't recall there is, at least in the employment context, Senator, I believe disparate impact is analysis in deciding discrimination cases in employment context, Senator.
And do you believe that there is any precedent on this issue of the impact on African-American voters on the issue that you wrote about in 2007?
I believe there are some. I think courts are working through it, and I think the case you're referring to is a amicus brief I worked on as an associate. We were representing a widow of a police officer who was murdered, and the person who murdered the police officer had sued the state of New York to be able to vote in prison while he was serving his life sentence. So we were representing that widow, and the widow had very strong feelings, obviously, saying.
But you, as a lawyer, took a position on a law, and so I'm asking, as a consequence of data and fact that tell us that there will be a desperate impact on specific populations, I'm interested to know if you are going to take those types of information into account when issuing rulings, if you're confirmed.
Senator, anytime there's potentially discriminatory issues, it's concern to me. I think it should be a concern to everyone. But obviously, I'll have to look at the precedent in the circuit and see what it is.
Have you ever taken a case challenging the constitutionality of laws that strip people of voting rights who have been convicted of a crime?
I have not, Senator.
Yeah. And in 2005, as a practicing lawyer, you wrote an article titled Illegals versus Legals. In the piece, you criticized the George W. Bush administration and its efforts to allow undocumented immigrants to work legally in the United States. You wrote, quote, by describing illegal immigrants as, quote, hardworking men and women who are pursuing better lives, President Bush blurs the distinction between illegals and those who came to America following the rules. Do you believe, sir, that an immigrant status has any bearing on his or her work ethic?
Absolutely not, Senator.
And is it your view that we should never refer to undocumented immigrants as hardworking because that paints them in a sympathetic light?
No, Senator. I think my point there was previously in the past, Congress in the 90s had defended legal immigration by drawing a distinction. And point of that article was by blurring the distinction, you may hurt legal immigration if the public starts viewing them the same. So I wasn't taking any position. I was describing the politics of that situation, of how immigration law is created.
When you were in law school, you wrote an article entitled Untruth in Academia. As an example of what you called, quote, epidemic lying in academia, you wrote that, quote, on most college campuses, professors repeat the mantra, 1 in 4 girls is a victim of rape or attempted rape. On what basis did you question the accuracy of this statistic?
Senator, I was quoting and summarizing a professor named Christina Hoff Summers who had written about that. But, Senator, sitting here today, I wouldn't write that because, frankly, I don't know, whether what Professor Summers had written was true. I had to summarize that. And obviously, Senator, this is issues of sexual assault. It's an incredibly important issue. As a father of 2 young daughters, I wouldn't want anything bad to happen to them. And, Senator, I can tell you, a close family member, became a single mother after ending an abusive relationship. And I've seen firsthand the turmoil it causes. And the most painful thing about it is this family member didn't tell me or my mom or anyone else or other family members because that was the culture then. You just didn't tell anybody. So hopefully things are changing now, and it's an issue I take very seriously, Senator.
Thank you.
Thank you. Now, Senator Kennedy.
Thank you, Mr. Chairman. Welcome, gentlemen. Congratulations. I remind you, of course, you're both under oath. I'm going to try to scrape away a little of the innuendo here today. Do either of you hate black people?
Absolutely not, Senator.
Do either of you hate Asians?
No, Senator.
Of course not.
Do either of you hate women?
No, Senator.
Do either of you hate homosexuals?
No,
Absolutely not, Senator.
Do either of you hate transgender people?
no,
Absolutely
sir.
not, Senator.
You're under oath now.
Yes.
Do either of you think that racially separate but purportedly equal schools are moral?
No,
They are not moral.
They're abhorrent, Senator.
Do either of you support sexual violence in the workplace or anywhere else?
No, Senator.
Absolutely not, Senator.
Do either of you hate little warm puppies?
I didn't hear, Senator.
Do either of you hate little warm puppies?
No, I
No,
love my
Senator.
dog, actually.
Okay, we got that out of the way. I want to talk about, Mr. Lee, actually, it's Professor Lee. Professor, I want to talk a little bit about the documents you turned over. You turned over 500 pages,
I did, Senator.
basically 2 novels.
Yes, Senator.
And they ask you for documents from, or papers you've written from college, post-college, and in high school. Is that right?
Yes, Senator.
Okay. How many hours did you spend putting all these documents together the first time?
I spent many, many hours,
How many?
goodness, dozens of hours looking for them.
Okay. The documents that you didn't turn over, were they on the internet?
Couple were, but they were on a private server that, again, it wasn't, we weren't aware of.
Who found them?
I believe Department of Justice working with me, we found them.
Okay, all right. And you turned those over?
Yes,
So we have everything now?
yes, Senator.
Okay. You talked about being in college, and I think you said, and what you wrote in college, I think you said I didn't know anything. But you wanted to know more, didn't you?
I did, Senator.
What was your GPA at Cornell?
It's 4.08.
On what kind of scale?
I think if you got an, my mom will be proud of this, but I think if you got an A+, you got a 4.3. But if you got an A, you got a 4.0.
So you made all A's?
I did, Senator.
Did you make a B?
I did not, Senator.
Well, you'll never be a senator, that's for sure. I take it you spent a lot of time reading and thinking and talking and debating. Is that right?
I did, Senator.
Is that what college is supposed to be about, making people think, not making them feel comfortable?
I discussed a lot of issues with a lot of people. Even if I didn't know all the facts, I wanted to learn things, and maybe sometimes, overzealous way, but I try to talk and debate with lots of people.
And did you test your arguments against, or your assumptions against the arguments of others?
I did, Senator.
Did you believe the same things when you left Cornell that you did when you entered Cornell?
No, I did not, Senator.
Okay. Geez, I thought that was the purpose of college. Do you consider that a bad thing?
No, Senator. I think college is a time of experimentation. Obviously, certain things I regret writing because I didn't know enough. But it was a learning process for me.
Let me. I don't want to go too far over. Let me ask you kind of a metaphysical question. Yeah. Uh-oh. What, Mr. Collins, I've kind of neglected you over there. What is your definition of justice?
My definition of justice, it would be to have the law fairly and faithfully applied to my situation. I would want, if I were a litigant, I would want the court to give me my rights in accordance with the laws as set down.
What if those laws are wrong?
If those laws are wrong, then we have a political process whereby people can ask for them to be changed. But in the courts, you have to follow the laws as written and the precedents as handed down.
What about you, Professor?
Senator, I think it's justice is treating people equally, no matter where they come from, who they may be, and treat them in equal fashion.
I think you're both right. I think justice is when people get what they deserve. And let me
Careful here.
and let me explain what I mean by that. It's broader than just crime and punishment. I think the people in Tibet, for example, deserve to be able to worship their God. I think it's unjust what China does to them. I think if someone rapes somebody, they deserve to be punished equally. Sentences commensurate with the crime and fairly applied, and you try as much as you can to treat everybody equally in equal circumstances. I think. Would you agree with me? And if you don't, that's cool. That a nonviolent crime can do as much damage as a violent crime?
Oh, it can, Senator. I mean, a serious fraud, for example, of an elderly person can have a devastating impact.
You mentioned earlier, Mr. Collins, about in the context of criminal justice, and I don't want to take it out of context, but we need to do better with nonviolent crime. Is that right?
Well, I mean, it's ultimately always up to the Congress to refine the sentencing system, and I think there's been a lot more thought put in certainly in the dozen years since I last testified on these matters about how to change those to reflect our current understanding of.
Well, these parents that just cheated, that just bought their kids' way into college. I read the indictment last night. I got 80% of the way through it. It's long. It'll make you want to scream. make you want to heave. I don't know if you can scream and throw up at the same time, but that's nonviolent. Do you think they should be punished?
Well, their case will be presented to the court, which will then, decide the issues in accordance with
Well,
the
that's a
law
very
and jury
diplomatic
trial.
offer. I think they should be punished. Anyway, I'm getting off subject. Thanks, Mr. Chairman.
Senator Whitehouse.
Thank you, Chairman. Before I ask questions of the witnesses, I wanted to bring up something that has transpired since Ms. Rao's hearing that, to me, calls into question how truthful she was with the committee. I know that virtually every standard and norm and practice of this committee has been broken through in the mad rush to confirm all these nominees, but I do want to at least remark on what I think is a very significant lack of candor on two subjects. Both Ranking Member Feinstein and I asked questions for the record, the written questions that come after the hearing, regarding the funding of an organization called the Center for the Study of the Administrative State that Ms. Rao ran. We asked specifically about the Koch Foundation and the Federalist Society and anonymous donors. And to Senator Feinstein, Ms. Rao responded, "To the best of my knowledge, the center did not receive any money from the Koch Foundation or from the Federalist Society," end quote. And to me, she responded, "To my knowledge, the Center for the Study of the Administrative State was not founded with money from the Koch Foundation. Moreover, the center did not receive money from an anonymous donor." Okay, we take that as her statement. But then we find through documents that were released through FOIA, the Freedom of Information Act, that the Center for the Study of the Administrative State, in fact, did receive financial support from both the Charles Koch Foundation and from an anonymous donor. In fact, in 2016, George Mason University received a $10 million donation from the Charles Koch Foundation and a $20 million donation from an anonymous donor, both earmarked with support for her Center for the Study of the Administrative State as a condition of the gift. The New York Times has verified this, reporting, quote, "a $20 million gift from an anonymous donor plus $10 million from Mr. Koch's foundation. According to university documents, the agreement called for bolstering Ms. Rao's center." Separately, it's a minor matter, but the dean of the law school made it clear that the Center for the Study of Administrative State received $300,000 in funding from an anonymous donor. So I know people don't want to talk about all of this, but this business of big special interests funding the Federalist Society, which picks the nominee, funding the Judicial Crisis Network, which campaigns for the nominee, funding these amicus entities that come before the courts, and now not being told what appears to be apparently not being told the truth about this, to me it's a real matter of concern. If we can't expect people who answer our questions for the record to tell us the truth, that's a very important hole in the process that we all participate in here. The second had to do with her contact with the Federalist Society about faculty candidates at this Center for the Study of the Administrative State. She was asked, did she have any contact with the Federalist Society when she was considering potential faculty candidates? She responded, no. And then she went on to say that the law school's hiring committee occasionally, and I'll quote her here, received recommendations from the faculty division of the Federalist Society. What she failed to disclose was that she was a member of the faculty division of the Federalist Society during this period. She was basically talking to herself on this subject. I don't know how that is not pertinent and disclosable information in response to that question. To me, it signals that nominees in this administration aren't taking this committee process very seriously because it is a treadmill. It's on automatic pilot, and everybody gets to go through, particularly at the circuit court level and particularly at the D.C. Circuit. So I just want to make a record of that because I'm very concerned about what is happening to this committee, and to me, this demands further clarification and explanation. My question is to Mr. Collins, and it is this.
That will not count against your time. You can,
Thank you. Posit a fossil fuel industry party with a case before you and explain to me how the adversary of that fossil fuel industry party could conceive that they will get a fair hearing from you, and specifically what your recusal standard will be when fossil fuel industry corporations come before you and fossil fuel industry arguments are made to you.
I identified, Senator, in my response to the questionnaire that cases that involved former clients of mine would be an area that would require an inquiry
That's
into
pretty
whether
obvious.
or not it was a case in which I should recuse under the applicable standards. And I would consult those standards in light of the particular case and make the appropriate judgment. And if that is to recuse in that case, I would do so.
Would it matter to you that a party or an attorney came before you with a feeling that they were dead on arrival in front of you because of your history representing the fossil fuel industry and that you couldn't give them a fair shot?
I would hope that they would not have, if I reached the judgment that I wasn't required to recuse, I would hope that they would not have that. I know that the standard looks at what a reasonable person who knows the circumstances would conclude, whether there was an appearance of impartiality or, a loss of impartiality in the circumstance. And I agree that the appearance of impartiality is often as important as the substance of it.
Let me read you something you wrote on behalf of ExxonMobil in the Kivalina case. You wrote, climate change allegedly results from the aggregate effects of greenhouse gas emissions from billions of sources around the world accumulating in the global atmosphere over the course of centuries, and thus it cannot be attributed to the defendant energy companies. So let me go through some pieces of that. Why did you say allegedly?
The reason why is purely the procedural posture. It was on a Rule 12 motion. It is a verbal tick of lawyers in Rule 12 motions always to say allegedly, because you're always taking the facts as alleged as true. And so that's what we were doing in that circumstance.
Okay, so let's look at the facts. Do you actually believe that climate change, as we are trying to reckon with it, results from the aggregate effects of billions of sources around the world accumulating in the global atmosphere over the course of centuries? Or is it more accurate, factually, to say that the climate change we're trying to reckon with comes from carbon emissions caused by the burning of fossil fuels that has taken place essentially entirely in the last century?
I continue right now today to be counsel in cases that involve alleged tort claims that are asserted arising from climate change, and so I don't think it would be appropriate for me to express a personal view on the underlying facts in a matter in which...
Well, you did. Here's what you said. I'm just asking you to defend it because it looks to me like it's false. And if you're willing to say something as false as the concern about climate change is something that relates to aggregate effects of greenhouse gas emissions from billions of sources over the course of centuries, when that is very distinctly not the problem, when it is very distinctly attributable to emissions from fossil fuel combustion, I think I'm entitled to challenge that to you and ask you to defend it. If you're unwilling to defend it, that tells me a lot.
The question, what you're referring to with the statement in the brief, and is the aggregate contribution of all carbon dioxide. And then the question in the litigation is the share of the contribution from the energy industry and how much that contributes to it. But it's not false to say that all of the carbon dioxide contributes to the problem. The issue was the amount of the contribution and whether there should be tort liability.
I think it is false to attribute what we discuss as climate change, using that word in its normal parlance, to things that happened hundreds or thousands of years ago, when we all know perfectly well that it has happened since the Industrial Revolution. And I know because of who your client was, that was the thing to say, but I think it is actually factually false and misleading to say that, because had those prior conditions continued absent the change of all this added carbon dioxide from fossil fuel, we wouldn't be having a conversation about climate change. That's why I think it's misleading. My time is up. That's why I think it's going to be hard for people coming before you as a judge to believe that if a fossil fuel company is on the other side, they'll have a shot with you, and I think that's not appropriate for people approaching United States courtrooms.
Yeah, would you want to say anything?
The only thing I would add is that I'm not sure the other side in the case disputed that all of the greenhouse gases that are emitted into the atmosphere and that remain there now from all of the sources intermix and contribute to the global phenomenon of global warming. So that statement that you read, Senator, that's all that said, and I don't think that's false. I don't think anyone really disputed it. The heart of the litigation was the amount of contribution of greenhouse gases from the energy industry and whether that should give rise to tort liability. And it was a legal issue about the availability of tort remedies for that.
Senator Lee.
Mr. Collins, in the context of a Rule 12b6 motion to dismiss, what's at issue are the facts as alleged, the allegations, and you frequently refer to allegations as such in the context of a motion to dismiss. Is that right?
Invariably, I do that, Senator.
And how are those allegations treated? Are in the context of a Rule 12b6 motion to dismiss, are you there to address or resolve disputed issues of material fact?
No, Senator.
In fact, can that even occur in the 12b6 context?
No, you'd have to convert it into a summary judgment motion if you were to try and do that.
And in order to do that, you'd be at a completely different stage of litigation.
That would be correct, Senator.
A stage at which facts have been adduced, facts have at least been gathered in the discovery process.
Correct.
So it would be impossible to refer to facts alleged without referring to them as allegations.
As I said, it was uniformly my practice to say allegedly, no matter what the facts were, that's how you do it in a Rule 12 motion.
You've served as a law clerk at multiple levels of the federal court system. At any time during your clerkships, did you conclude that the federal court system is corrupt?
Never, Senator.
In your experience, in your career as an attorney, did you ever see evidence of corruption?
No, Senator.
Is it your position that an individual who's been nominated to serve as a federal judge in the U.S. court system needs to place at issue his or her personal political views?
No, we're not to take our personal political or policy views with us to the bench. That's not the role of a judge. Is very different. It really is to follow the law, the precedent, the statutes as written, the precedents as established by the Supreme Court, the other precedent established by the Ninth Circuit. That's what I would be bound to follow.
Right, right. New York Times versus Sullivan involved a corporation, did it not?
Yes, the New York Times company was a petitioner.
And in that case, the Supreme Court concluded that New York Times, a corporation, had rights that were protected under the First Amendment.
That's correct, Senator.
As a lawyer, you're trained to find ambiguity. Lawyers deal in ambiguity and harness ambiguity in the law to make legal arguments for their client. As a judge, of course, your role is a little bit different. Sometimes your role involves identifying an ambiguity, and one set of rules might apply if there's ambiguity in the statute, another set if there's not. You think you're any more or any less likely than the average lawyer who becomes a judge to identify ambiguity in statutory text?
No, I think that have a lot of experience with briefing issues of statutory interpretation. I'm familiar with the relevant canons, and I think I could fairly apply those consistent with established precedent.
Thank you. Mr. Lee, I regretted a few minutes ago that one of my colleagues invoked the memory of your late father in connection with questions. I consider that inappropriate and would call upon my colleague to apologize for that. Having lost my father 23 years ago this week, I relate to the difficulty that can come to anyone when someone tries to invoke the memory of a departed loved one in an effort to shame, humiliate, embarrass, or retaliate against someone with whom they disagree. As long as the name of your late father has been invoked, I wanted to invite you, if you're interested, to tell us a little bit about how your father informed your life, about how you became a better person as a result of his life and his example and his choices throughout his life and his experience as your father.
Great. Yeah. Thank you, Senator, for those kind words. My father was my hero. He was the hardest working man. And whenever we faced difficulties, he always tried to uplift us all. And I think of one experience about 35 years ago. I wanted to go to Disneyland. I pestered my parents to take me to Disneyland. And they finally agreed to take me to Disneyland with my 3 sisters. But to save money, they decided to take some Korean food, kimbap, which is rice with Korean vegetables wrapped up in seaweed. So this was 35 years ago. That kind of food was quite exotic. So when we were there and we opened up our food for lunch, you know, again, little kids started coming up, and some said it smelled. Others said it looked like feces. They used a slightly different word. And one of them I remember was, you know, pointing to my parents, making kind of faux Asian-sounding names and pulling their eyes. And I remember, you know, and when you're a kid, smallest things seem like the world to you. And I remember the next day, maybe because I was young or because I felt helpless, I blamed my dad for this whole thing. And I said, I want to go back. I want to go back to Korea. I said, you never asked us if we wanted to come here, move to a new country. And, my dad was a Stoke man, but he said, I know it's tough for you. It's tough on your sisters. It's tough on me and your mom. But one thing I always remember, and maybe I didn't take it as seriously when I was younger, but something that I always remembered and learned more as I got older. He said, I know it's tough here, but he said, you don't want to go back. He said, because things aren't fair there. He said, the families that control the conglomerates there, the chaebols, he said, they control the government, they control the economy, they control the laws. So you're not going to get a fair shot there. But he said, here in America, he said, things are different. He said, it doesn't matter that you're not white. It doesn't matter you weren't born here. It doesn't matter that our family doesn't have wealth or power. He said, everyone here is treated equally. And my dad wasn't a lawyer. He never read the Federalist Papers. But he had a gut understanding of what makes our country and our Constitution so great, so powerful, and so unique in the world. And I've always remembered that. And Senator, I know sometimes we haven't lived up to those ideals that my dad believed in, and that's embodied in our Constitution. That's clear when we read our history books. But I think all of us try to strive to live up to those ideals despite our different backgrounds and different political views. And Senator, if I'm lucky enough to be confirmed as a judge, not only will I take an oath to the Constitution, but I'll always try to honor the faith that my dad had in America and make him proud.
I'm confident he would be proud of you. Thank you.
Thank you. Just for the record, Ms. Rao submitted her answers to the written questions on February the 11th. So, Senator Durbin.
Thank you, Mr. Chairman. Mr. Lee, thank you for sharing that story about your father and your family. It was an important part of an insight into who you are and where you came from. And that is really, as you both should know by now, what this is all about. Senator Kennedy's list of 5 or 6 basic questions, if that were all it took for us to decide the fate of a nominee, these hearings would be a lot shorter than they are. But what we try to do is to go beyond the simple question about a feeling toward a group or an issue and get some insight into your character, insight into your values, to project what you might do when you're given an awesome a degree of power as a judge to literally decide a person's fate and that comes before you. And I think that is why we take the time to look back in history to try to assemble in our minds who you really are. And Mr. Lee, you were a prolific writer in Cornell in the early stage of your life. I don't know how you made time for class because you were generating essays on every political topic of the day, and most of them leaned in one direction. They were extreme, from my point of view, from the right-wing perspective, and in some points were negative about certain groups, in some points mocking certain groups in our society. They were harsh, and some of them, as I indicated, were mean. And what you've told us was that you had a major blind spot. Those are your words, and that there has been a change. Tell me about that road to Damascus. Tell me what changed in your life that took you from an extreme, harsh point of view on the right to where you consider yourself today.
Good. I understand your concerns, and I appreciate that question. Senator, a lot of the things I wrote when I was young, 18 or 19, again, part of it was lack of maturity. Again, when you're young, you think you know everything, and not only that, you think everyone else is wrong, and you think only if I can speak loudly and everyone hears, I can solve all the world's problems that everyone else can't solve. And clearly, that's not the case. As you get older, you realize you know very little when you're young. And part of it also is, I think when you're young, you think being snarky is being witty. As you get older, I think you realize that, frankly, comes off as insensitive or tone deaf. I've learned that. And I can tell you through my life experiences in the past 25 years, there have been so many good, bad, that have taught me and shaped me, I think, into a more empathetic and caring and understanding person. Obviously, the most obvious one is becoming a husband and a father. I think changes you for the better. My wife makes me a better person every day. You become more sensitive to issues. Having 2 daughters, I think you become more sensitive to issues because, just the thought that my daughters wouldn't be treated equally just, makes my stomach churn. But there have been also just other things that professionally, I've done a lot of pro bono work over my 20-year legal career, and most of them have been, for the poor and for members of marginalized groups. And that experience, you spend a lot of time with clients, it opens your eyes a lot, because you know things, certain things, abstract concepts, statistics. But I remember representing an African-American individual who was beaten after a routine traffic stop, and we represented him and went to trial. And again, you see these statistics about disparities. But when he, tells you and looks you in the eye and says, that he gets afraid whenever he sees law enforcement, even if nothing happens, and that really hits you. Again, you may know things in abstract concept, but when someone tells you that, it really opens your eyes and opens your heart. So, on a professional level as well as a personal level, you learn these things as you get older. There are even, small things where, when I was a young lawyer in New York, I decided to volunteer. I love baseball, so I wanted to volunteer in Harlem, teaching baseball and mentoring kids. So initially it was, my love of baseball, so I'll do that. So I took the train up to Harlem. Most kids were from South Bronx and East Harlem. And whenever I showed up, these kids, they're like 8 or 9 years old. They would come running to you with big smiles on their face. And initially I thought, these kids think I'm really good in baseball. But then you realize, the reason why they're so happy to see a stranger who has, frankly, mediocre baseball skills is that these kids don't have the support system that, so many of us have had and we've just taken for granted. And so they're just happy to see that. So when you...
Mr. Lee, sorry to interrupt you. My time is up, and I know what you're saying is heartfelt, and I certainly understand the message. And the point I want to get to is this, and as I close, Mr. Chairman, I'll be very quick in closing. Most of us are looking for someone who is not only a good lawyer, but a good person, because your power on the bench goes way beyond the law as far as I'm concerned. I am not one of these people, and I hear it said on this committee so often I almost want to get up and leave, that this is somehow robotic law. Here's a precedent, here are the facts, well, we know what's going to happen. That's not how the courts work. It's not how judges work. People bring a lot of things into the courtroom, and part of what they bring are their life experiences, and whether or not they can be empathetic with someone standing before them who doesn't have a fighting chance, who couldn't afford Mr. Collins and his legal team that is obviously well respected by those who can afford good representation. And the question is whether that person has a chance before you, whether you can possibly look through that person's eyes and understand what the world looks like, and whether looking up at the bench and looking at you, they're wondering, I'm cooked. I don't have a chance here. That, to me, is what this is all about, to try to not guarantee your outcomes, but at least guarantee the thought process that is empathetic to that person and understands their whole life may be hanging in the balance of your life experience and the values that you brought from it. Thank you, Mr. Chair.
If I could, just to build on what Senator Durbin said, I'm very sympathetic that myself. So let me just give you my 2 cents worth of how I look at this. There's what you say when you're young, and there's what you do when you get here. So I always look, and it's not outcome determinative, but the ABA ratings are pretty important in terms of the professional character. Like Sotomayor said at a speech, more times than not, a Latino woman probably would reach a better decision than a white male. And everybody, oh, she's racist. No. I found nobody to suggest that when it came to doing her job as a judge, she would take that view toward the litigants in front of her. As a matter of fact, I think she's just trying to say, you know, what you said, we all have different experiences, and nobody with Kagan or Sotomayor ever suggested, as being a lawyer, an advocate, or whatever they were doing, that they were unfair to their coworkers, that they held a grudge, that they were radical in their representation. And the only thing I would suggest to the committee about these 2 gentlemen is I understand you would not have picked either one of them. No Democrat would. The people who work with you through these years have all said decent people who take a different position than I do, and ethical. So what knocks you out with me is not your philosophy on the personal side. I'm a qualifications guy, but if I really believe you're holding a grudge against something or somebody, then those are the kind of people we want to knock out. And we've had 2, and I'm going to tell you who they were. The reason I feel comfortable is because when you look at who these gentlemen have worked with, it's pretty unanimous. It's not whether I agree with them or not. They're just decent lawyers and ethical people. And to me, on the people side, that's what I'm looking for. On the philosophical side, I definitely understand that you disagree with the judicial philosophy. That to me is, I did that with Sotomayor and Kagan, but wasn't outcome determinative for me. Senator Blackburn.
Thank you, Mr. Chairman, and thank you for those remarks to kind of put a wrap around all of this hearing. Mr. Collins, are you still teaching at Loyola, or is that in the past?
I was invited to come back. I was invited to come back again, but because of
Okay,
nomination.
let me ask you this. If you were teaching and you have a class in front of you, what would you advise them on their professional conduct after going through all this process that you're going through right now?
Well, I would tell them the same thing that, I would have said before, which is that, they need to understand the law, work hard, and they need to always be honest about their cases. They need to be honest about what the state of the law is, how strong the arguments are, and honest about the facts and where the weaknesses in their case may be.
Great. I appreciate that. And I appreciate your family is sitting there with you and enduring this questioning. And I know they're going to be ready to get out of here and go have lunch. They've been good and attentive. And Mr. Lee, your family there, I think your mom is probably the chief mama in charge and probably does a very good job. I've appreciated you all being here. I know you did some work at the White House with the 9/11 victims, and I know that must have had an impact on your work and on your point of view, your worldview.
Yeah, yes, Senator, and I'd started my career in New York during when 9/11 occurred, and it's something obviously if you were of age during that time, it affects you, and just the victims and people who are affected, and just the strength that you see is just so inspiring. A lot of times at work, sometimes you feel frustrated or you think it's tough, but then you hear these survivors and people who've suffered so much and they're so strong. I mean, it's very inspiring.
And I would think that coupled with the pro bono work that you have done has had an impact on the empathy that you bring to helping people. And I would think that would impact your ability to walk in another person's shoes for a little bit. There was one case in your pro bono work where there was a death row inmate that wanted DNA tested, and I think that one was covered in the New York Times, and I appreciated reading about that. Was that your most impactful case, or was there another?
I think that was an important case because I think there were serious allegations of racial bias that may have affected that case, and obviously the stakes are huge. I think the most important, impactful case in a way was representing an inmate who alleged that he had been beaten by prison authorities, and he was African American. The prison authorities were all white, and we went to trial. It was before almost all white jury, and I remember him telling me, he says, "I'm telling you the truth, but I don't know if I'm going to get a fair shake," because he's pointing to who the defendants are and the jury, and I frankly didn't know what to tell him other than we do our best, and we did win that case on a jury trial. The jury agreed with him, and and he was so happy, and he said he'll take me out to lunch once he's released. He said he'll take me out to lunch. So it was very felt good about it to have him just have a little more faith in our justice system.
And that's what you want. You want people to come before a judge and realize that they're getting a fair shake. Well, there are three things that I like to ask nominees. Will you be fair and impartial on all of the issues that you consider, regardless of your personal beliefs? Yes or no?
Absolutely, Senator.
Absolutely, Senator.
Thank you. Will you promise to put aside any bias or views that you took from a prior advocacy position?
Absolutely, Senator.
Absolutely, Senator.
Can you assure us that you will apply the law and the Constitution equally to every party who comes before you in your courtroom?
Absolutely, Senator.
Absolutely, yes, Senator.
Thank you both so much. I yield back. Thank you, Mr. Chairman.
Senator Coons.
Thank you, Chairman Graham, and thank you, both of you, for the opportunity to question and for your willingness to serve. If I might, Professor Lee, Mr. Lee, first, thank you for sharing the story of your father's optimism and determination and his faith in our nation. One of the things that makes our system work is rules and process. And as a judge, you will be asked to enforce rules and process. And as an attorney, I'm a bit obsessed with rules and process. And as someone who used a state judicial nominating committee to consider nominees, candidates in Delaware, I was concerned with what I got in terms of a background on which articles you provided and when. I recognize that views mature over the course of a lifetime, that perhaps things you wrote in college don't reflect your views today. But I wanted to make sure I understood this because the number and the gap was pretty striking to me. Am I right that you did not provide literally dozens of articles that you yourself wrote to the selection committee impaneled by the two California senators?
Senator, the questionnaire for the Judicial Advisory Commission, I think it was question 34A, asked for all legal writings. So I provided my legal writings. I did not provide, non-legal writings that I had written in college because I did not believe they were responsive. But obviously, with respect to the Senate Judiciary Questionnaire, it asked for all writings. So I tried to get all of my writings.
How many times did you have to supplement the committee questionnaire?
It was several, I apologize for that. It was frustrating over the past couple of weeks, as we discovered additional articles in these various non-public sources, we supplemented, I think, total of around 50 or 60 pages.
Yeah, my sense here is that ultimately we've gotten 88 articles, writings from you. And some of them, most of them, in fact, only 11 of those were initially submitted. So 77 of those were not submitted to the In-State Judicial Nominating Commission, and the vast majority of them weren't submitted even when you were initially nominated. There were 47 writings added in January of 2019, and then another 5, and then another 27, then another 4, then another 2, then another 1. Then as recently as March 6th, 7 more articles. And part of what troubled me was hearing that these were relatively easily found by committee staff, just using public searches. Can you assure us that we now have all of your published articles, that we actually now have the full record to look at?
Senator, I believe so. Again, I've submitted over 500 pages, and I believe they are. Again, these articles were from 20 to 25 years ago, and again, pre-internet era, so most of them were not on the internet, and I didn't have a master index of everything I've written, even as a teenager. So I believed I had collected everything, and when we discovered that it wasn't, we supplemented it, and again, I apologize to the committee for the frustration it caused.
I mean, the notes I have here say that of the 45 that supplemented the initial filing, 5 of them were from the same date, same publication as other articles that were in your initial disclosure. So to me, this was very concerning. Just the number, the length, the difficulty. Look, folks who I have, who are now sitting on the bench in Delaware, commented that our questionnaire is very thorough, very long. But frankly, I think it's important to respect that process. Is it critical, in your view, for judges to be thorough and honest?
It is, Senator.
One of the things you wrote that was disclosed, and I'm just quoting, this is a college article, but you said, and I quote, "Cries of racism often stem from isolated incidents and from unreliable studies based on statistical chicanery." I don't know if I'm pronouncing that word right. Do you still stand by that statement?
Yeah, I don't, Senator. I mean, obviously, discrimination is real. My family has suffered it. I think some of the language, again, that I used in college, again, when you're 18 or 19, you don't have the nuance. You're trying to express a gut feeling based on your personal experiences or limited knowledge. So, you don't understand the complexity of the world. And I regret some of that language that I used.
Thank you. Let's jump forward to something you wrote in 2001. So you're not 18, you're not in college, you finished law school. This was while you were a clerk. You said that, and I quote, "Left-leaning lawyers have successfully waged a rights revolution over the last 3 decades." What rights were you referring to, and what should we conclude from that?
Thank you, Senator. I think some of the things I was referring to, I think there was the mentally ill who were freed from institutions. And I think the purpose of that article, Senator, was my concern that, because I'm a strong believer in pro bono, as you've seen from my track record, and most of my pro bono cases are just representing individuals who are poor or who don't have access to justice. And my concern was that if too many lawyers take pro bono cases that are politically charged or very sexy, that people would lose support. People would not support pro bono because they view it as too political. And if you also see later in that article, I mentioned that conservative groups were doing the same as well. And I was concerned about that as well, that if pro bono is seen as a vehicle just for the left or the right, the general public and the legal profession may not support pro bono because they just view it as a political tool. So that was part of my concerns that motivated that article.
If I hear you right, your argument, your advocacy here, where it seems, at least in the quote, you're arguing against a recognition of a broader understanding of rights. You're asserting your argument was, we need folks who are willing to go out there pro bono and just handle workmanlike, day-to-day cases representing established rights, established claims, and not seeking to advance a particular agenda?
I don't know if I was saying it that broadly, but it was just my concern that if too many of the pro bono cases involve politically charged issues, people wouldn't support pro bono because they just view it as too political. That was my concern at that time.
Thank you. Let me ask, if I might, one question of you, Mr. Collins. You suggested in a 2002 speech that, and I think I'm quoting here, "General technological advances may legitimately have the effect of reducing the degree of privacy that existed when the Fourth Amendment was adopted." Close quote. Technology and the ability to collect personal data has not just rapidly advanced, it has changed the frontiers of virtually everything about privacy and what data can and should be collected. Do you believe an individual's right to privacy, the underlying right, the recognition of a right to be safe in one's papers and effects in the Fourth Amendment, has decreased because of these technological advancements?
No, I think the kind of point I was making, I think, is validated by for example, the Supreme Court's decisions in Riley and Carpenter, which have made changes from prior precedent in the Fourth Amendment area with respect to search incident to arrest, with respect to Smith v. Maryland, in light of the significant privacy concerns by the technological changes. So that's the kind of point I was making, and I think those cases kind of validate that intuition.
Thank you, Mr. Collins. Thank you, Mr. Lee. Appreciate the opportunity to question you today. Thank you, Mr. Chairman.
Senator Klobuchar, we have 8 minutes left on the vote.
Okay, well, then I better hurry.
Well, no, I don't want you to hurry, that's the
No,
point.
it's okay. I'd rather
So
just do it.
Do you want to,
I'll just do like 5
okay,
minutes and then
whatever,
run over
but
there.
if you need to
That
come
works.
back,
They'll tell me if I can't make it, and I'll put the rest on the record. So,
Okay.
Mr. Collins, I know you talked about this with Senator Feinstein, but you drafted an amicus brief in a case before the Supreme Court called Hamdan v. Rumsfeld, in which a detainee challenged the legality of the military commission convened to try him for conspiring with al-Qaeda. You argued that the Constitution's commander-in-chief provisions empower the president to establish military commissions. The Supreme Court disagreed. What do you believe are the limitations on the president's commander-in-chief powers in a time of war?
Well, the particular issue that we addressed in that amicus brief really just went to sort of what was the inherent scope of the authority to invoke military commissions in a sort of pre-statutory period. So we kind of went through the history, and it was primarily a historical brief going through the history of military commissions. It ultimately, given how the court disposed of the case, my brief proved to be irrelevant because the court decided
But my question is, what do you believe are the limitations on the president's commander-in-chief powers?
I don't think it would be appropriate for me sitting here today to opine on the substance of that question. I've already learned from the chairman's comment that I've not kept up with this area of the law because I wasn't aware that the statute had specifically prohibited the trial of citizens. So I wouldn't purport to address it off the top of my head.
Okay. Mr. Lee, I understand that you worked as associate counsel and special assistant to President George W. Bush. According to an article in Super Lawyers, you were involved with the White House's response to congressional inquiries into the firing of several U.S. attorneys and helped to evaluate the assertion of executive privilege. What did you take away from that experience, and how do you think it will impact your evaluation of executive privilege in the future?
Senator, I think what I learned was the balance you have to take into account between the legislative prerogatives, and it's very important for the legislature to have oversight. That's a key constitutional role. But there's also countervailing value of being able to provide unfettered legal advice within the executive branch. So there's a tension between the two, and I think you have to balance the two. You have to learn to accommodate and try to come up with a compromise deal in those situations.
In an opinion written by Chief Justice Berger, a Minnesotan, a unanimous Supreme Court held in U.S. v. Nixon that a president could not assert privilege over materials subpoenaed in a criminal trial based only on the generalized interest in confidentiality. Do you believe that the court properly asserted jurisdiction to resolve the conflict between President Nixon and the special counsel?
Senator, I'm vaguely familiar with the case. I never read the opinion, but obviously it's an important decision, and as an inferior court judge nominee, if I'm confirmed, I will faithfully follow it.
In an article you wrote for the American Enterprise in September of 2002, you criticized the use of disparate impact claims, which allow plaintiffs to show that a policy has a discriminatory effect even if it wasn't motivated by an intent to discriminate. The Supreme Court has repeatedly affirmed that disparate impact claims are an important tool to protect against discrimination. Can you speak to how you would approach a case involving a disparate impact claim if you're confirmed as a federal judge?
Great. Thank you, Senator. Obviously, the Supreme Court in the employment context has held the disparate impact claim could be viable. I think there's a test. You provide disparate impact, then the other side has to proffer a reason to show that there were other factors involved, and the other side can show that that is pretextual. And Senator, obviously, I will faithfully follow all precedent, and you have to take discrimination claims very seriously. It's something I believe in personally as well as a racial minority, and it has to be taken very seriously.
Okay. Mr. Collins, you wrote an amicus brief in Burwell v. Hobby Lobby, in which you made a broad constitutional argument that the First Amendment's free exercise clause extends to a for-profit corporation's exercise of religion. If corporations have a protected right to exercise religion, is it your opinion that corporations could also say, refuse to hire someone because of their sexual orientation, or what about the religion that they practice?
The primary issue that we addressed in that case was the statutory issue about what was the coverage of person within the meaning of the Religious Freedom Restoration Act. That required some consideration of the subsidiary question of how it had been treated under the free exercise clause, and we looked at one case in particular where a corporation had been allowed to assert a claim. But I don't think it would be appropriate for me, particularly as these issues are working their way through the court, to opine on some of the open questions that I know are being litigated right now.
All right, thank you. I think I'm going to go vote, but I appreciate it. I'll do a few other questions on the record. Thank you.
Thanks, Senator Klobuchar. I think that's it. We'll hold the record open for written questions till March 20th. Thank you very much. You both led consequential, good, and decent lives. I appreciate what you have done thus far for our country, and I think in both of your cases, the best is yet to come. Hearing's adjourned. Since I wrote it, that's the one I got.